Most contractors I talk to assume the answer to this question is simple. If someone's a 1099, workers' comp isn't your problem. The paperwork says independent contractor, so the liability isn't yours. That assumption is costing some of them a lot of money, and in a few states, it's costing them their license. Stick with me. If you're running subs, this one is definitely worth understanding before your next job starts. Let's start with the general rule because it's real and it's accurate. Employers are generally not required to carry workers' compensation insurance for legitimate independent contractors. That's the rule. And if someone is a true independent contractor, workers' comp typically isn't your obligation. Here's where it gets a little more complicated. The 1099 form is a tax designation. It tells the IRS how you're paying someone. It does not determine your workers' compensation obligation. Those are two different legal questions governed by two different tests. What determines your workers' compensation obligation is the actual working relationship, specifically how much you control excise over or how or when the work gets done in the first place. Here's the risk that most contractors don't think about until it's too late. If you're telling a subcontractor when to show up, what tools to use, and exactly how to perform each task, you're exercising the kind of control that courts and state agencies associate with an employment relationship. The IRS uses one test, the Department of Labor uses another. Your state's Workers' Compensation Board may even use a third test. They don't always agree on the same worker. And if a worker gets injured and pursues a claim and a court determines that the working relationship looked more like employment than independent contracting, that worker can be reclassified as an employee after the fact, retroactively. That reclassification triggers workers' compensation obligations for a worker your policy never contemplated as an employee. So what actually happens when a 1099 sub gets hurt on your job site? What happens? If they don't carry their own workers' comp coverage, they may file a claim against you. If they're reclassified as an employee after the fact, your carrier may deny the claim altogether because your policy wasn't written to cover that person as an employee. Now you're facing a tort claim with no coverage behind it. And here's what most contractors get backwards. They think the sub not having workers' comp protects them. It does not. In many cases, it makes the exposure worse because now the injured worker has no other avenue for recovery and you're the one with something to reach. Now let's talk about waivers because this comes up a lot in Louisiana and in the Southeast altogether. Some states allow independent contractors to waive workers' compensation coverage by filing an exemption with the state. A valid waiver means that that contractor is not required to carry their own coverage. And here's what that waiver does not do. It does not automatically protect you from a claim if the person is injured on your job site. In most cases, in most southeastern states, a valid waiver filed by a subcontractor doesn't insulate you if the working relationship is later found to resemble employment. The waiver protects them from being required to carry coverage. It does not transfer the risk away from you. Here's what to do before any subcontractor sets foot on your job site. First, require a certificate of insurance showing their workers' compensation coverage before they start the job. No COI, no work. This is the single most protective step that you can take. And if a sub carries their own coverage and gets hurt, the claim goes to their policy first. Second, have your subcontractors sign a written independent contractor agreement that documents the nature of the relationship, that their control over their own work and their responsibility for their own insurance is there. Written documentation matters when a classification dispute comes up. Third, Ask your agent how uninsured subcontractors are handled on your current workers' compensation policy. A lot of contractors don't know this. Many policies include provisions that can add uninsured sub payroll to your annual audit and raise your premiums at renewal. You may be paying for exposure you didn't know existed. If you're running subcontractors right now and you're not sure how your current policy handles them, that is worth a 15-minute conversation before your next job starts. Book directly at the link in the description, or you can call us at 318-423-7445. We're at callwatley.com, and next week we're getting into additional insured status, what it actually means when a GC requires you to add them to your policy and what rights that gives them over your coverage. That one drops next Tuesday. See you then.